This podcast is sponsored by Murgatroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgatroyd.com/podcasts.
Welcome to the fourth season of Murgatroyd's Innovation Talks podcast. We're delighted you've joined us. If you have any questions, you can email us at innovation.talks@murgatroyd.com or via @Murgatroyd on Twitter. And please remember to subscribe so you don't miss any future episodes. So let's go straight into today's podcast.
Hi, I'm Terry Devlin. I'm a European patent attorney in the Aberdeen office of Murgatroyd. And today I am joined by James Brown.
Hi there.
James is also a patent attorney, and he's actually the lead attorney in the office, and he's vastly experienced in all areas of IP. And today we're going to be talking about identifying gaps in your IP protection.
Looking forward to it.
Absolutely. So firstly, an important question is, how might one identify gaps in a client's IP protection? Do you have any thoughts about that, James?
Yeah, well, very often with clients, at a fairly regular interval, maybe every 3 months, every 6 months, conduct a review of their IP portfolio, taking into account the input from their sales team in terms of where what's happening with their product lines, and in particular what's happening on a territory basis, so that we can consider what IP protection they've got so far and what they're likely to need in the future. And that could form part of an IP audit, which is the subject of a separate podcast. But regular IP reviews can be really useful stroke critical to ensure that the right protection is in place for clients. Basically to make sure that if you're going to be launching a new product line, that if you launch it on the Monday, it's not copied and you've got competing products on the following Monday.
So from a practical point of view, how would you go about conducting such a review, James?
So there are obviously different types of IP. So brand protection, trademark protection, patent protection, design protection. We would look at it on a product line basis and identify what IP can cover each product line and what type of IP that is. So let's take the example of a client that's registered their trademark, the main overall house mark, as it were, and we would ensure that when each of the product lines is actually featuring that trademark on the product, on the packaging, etc. If it's not, then advise the client to do that so there's at least protection for the overall house mark. So taking the example of a car, clearly cars have all got the house mark of the brand on the car, either on the bonnet or probably likely on the tail as well. But if there's a number of product lines, so take a BMW 3 Series, they've also got a 5 Series, they've also got a 1 Series, etc. And if they can, we'll be advising clients in terms of, look, you probably want to also protect the actual name for each product line so that you've got specific protection for each line. So that's from a trademark point of view. We would do the same with looking at registered design protection for the shape and appearance of the product, and similarly for patent protection that will be protecting the specific technology within each product line, identifying which patents the company owns are protecting the various different technology features within the product. And it may be that in the R&D process that new technology is developed, for example. And if that's the case, then we'll be recommending a new patent application would be filed to protect that. And similarly, when a new product line comes out, looking at the registered design protection to protect the shape and appearance of it. And if it's a new brand name that will be used for that product line, then first of all, conducting trademark clearance searches to make sure that the client can safely use that new product name, the new brand name, and assuming it clears the trademark clearance process, then applying to register that brand name as registered trademarks in the key territories for the client. IP rights are primarily granted on a territory basis, so each government, each country will have its own IP rights system. There are supranational systems, but in principle, you're looking at each territory that you're selling into. And it may be that obviously some territories are more important to your company than others. And whilst no company in the world will have IP protection in every single country around the world, particularly patent protection, because it can be a bit more expensive, then you look and see which countries are most important to you, and you protect your IP in those countries.
That's very interesting. Now, going back to the point you originally made about different product lines a company might have. If the products are consumer items or tools that are used in a field and have a value, thinking about the possible protection for them, I'd be thinking that a patent might be the most appropriate form of protection for certain products. In terms of timing of reviews of gaps, do you think it's important that that should be done at particular time intervals given the novelty requirements?
So certainly in the R&D process, when you're looking at a new product with the plan to launch a new product line, it's important to do that absolutely before you launch the product, indeed before you make any non-confidential disclosure of the product. One of the most important pieces of practical advice that I'll give a client, particularly if it's a client that's got maybe a small or medium-sized engineering department, but they've also got a sales department, is make sure that you keep the sales team away from the R&D that's going on, because sales teams are all geared up to tell the world about your product. But from a patent point of view, it's important not to do that until you've at least spoken with a patent attorney to obtain advice on whether it's patentable or not. So yeah, keep the R&D away from the sales team until you've at least looked at protecting it.
Well, I think that is it is actually very good advice. I have seen examples where you would have, for example, a sales team, but particularly a sales team in the United States, where the rules up until probably quite recently were quite different about disclosure, where salespersons in the States publicise widely a product through YouTube and through websites, and then the decision is made over a year later to patent this by the UK division, at which point it becomes a very difficult thing to achieve. So that's a good point to remember.
Good stuff.
Another question that springs to mind relates to the lifespan of the various types of intellectual property, because they're not all equal necessarily. Would you have any thoughts or advice for a client whose patent, which may have been very, very important to their commercial activities, is coming towards its expiry at around 20 years?
Yeah, good question. We've, particularly over the last few years, we've been doing a lot of work with clients in that area, particularly because of the financial incentives that were set up by, for example, the Patent Box tax reduction scheme that came in a number of years ago. But there's been a big push, first of all, by the government to encourage R&D, and that's where the Patent Box tax reduction scheme came from. And basically what it does is it encourages companies to protect their technology with patents. And if they do so, they get a reduction in the corporation tax rates that is payable on the profits that are generated from the sales or rent of those new product lines. And so, for example, we've looked at, say, a client that has had a really successful product line, has been covered by patents, but maybe the patent has just run out, or it's just a way to run out. And in the past, what the client may have done is just let the patent run out, and they'll continue selling the product. And maybe if they've had a successful brand name for that product, then they've relied just on the brand name. But what that strategy in the past has done is that it's enabled competitors to come out with competing products, and particularly if they sell them under a different brand name, then there may not be much that the client could do. However, particularly the incentive with the Patent Box tax reduction scheme, it's really encouraged a regeneration of the IP cycle. So what it's enabling and promoting companies to do is to very regularly look at the patent protection that they have for their products, and to look at the product and maybe try and enhance the product, to improve the product, to modify the product. And particularly if the improvement that's made is patentable, then we'll work with the client to draft and file a new patent application. And what that does is it sets up consider it a minefield for competitors to have to navigate. So even though once the original patents run out, they may be able to compete on the old product. If the client can continue to regenerate the IP, then they won't be able to compete with the new features that the clients come up with.
So it sounds like that provides more than one benefit to the client, in that it could be breathing life into products which otherwise might be considered becoming obsolete, but also provides protection for an improvement to these products. And that could then cause another 20 years potentially of IP rights.
Absolutely. And also has the added benefit that the client's also obtaining a reduction in the tax, in the corporation tax that they're paying on the profits that would otherwise be due. So it really is a win-win for the client.
It sounds like a great advantage. So James, thank you very much for your insight. It's much appreciated, and I found it very informative. Thank you.
Thanks for your time today. We hope you found today's podcast valuable. And remember to subscribe so you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgatroyd.com.